May 11, 2023. Unit 10. Real Property Security Devices. 1. Need not be. Need not be. Need not be. To be a negotiable instrument, a note or draft need not be a sum certain. B. Signed by the payee. C. An unconditional promise or order. D. In writing. B. Signed by the payee. Negotiable instruments. While not money, negotiable instruments are freely transferable and are used in lieu of money. They are either promises to pay, notes, or orders to another to pay, drafts. To be a negotiable instrument, a note or draft must be a in writing, a signed by the maker, an unconditional promise or order to pay another, and a payable on demand or at a specific time in the future, for a certain sum in money, and payable to the order of the payee or to the bearer. 2. Refinancing without a discernible benefit to a borrower is a. Prohibited by the Service Members Civil Relief Act of 2003. B. A violation of the Truth in Savings Act. C. Considered predatory lending. D. A violation of the Mortgage Forgiveness Debt Relief Act of 2007. C. Considered predatory lending. Refinancing without a discernible benefit to a borrower is considered a predatory lending practice, which refers to lending practices that take advantage of vulnerable borrowers, often resulting in excessive fees, high interest rates, and ultimately, unaffordable loan terms. While there may be legal implications to such practices, it is not specifically prohibited by the Service Members Civil Relief Act of 2003, the Truth in Savings Act, or the Mortgage Forgiveness Debt Relief Act of 2007. However, various state and federal laws have been enacted to prevent and punish predatory lending practices. 3. A maker could not use which as a defense against a holder in due course? A. A raised note. B. Prior payment of the maker to a previous holder. C. A note given for an illegal purpose. D. Legal incapacity of the maker. B. Prior payment of the maker to a previous holder. Under the holder in due course doctrine, a holder who meets certain requirements and takes possession of a negotiable instrument for value, in good faith, and without notice of any claims or defenses against it, is entitled to enforce the instrument as if it were the original payee or holder. A maker is generally prohibited from using certain defenses against a holder in due course, including the legal incapacity of the maker, a raised note, or a note given for an illegal purpose. However, if the maker has already made a prior payment of the instrument to a previous holder before it was acquired by the holder in due course, the maker may use this fact as a defense against the current holder. Therefore, option B is the correct answer. 4. The usury law interest regulations did not apply to A. Seller purchase money financing. B. Cash loans. C. Loans made or arranged by mortgage loan brokers. D. Both A and C. Answer D. Both A and C. Usury laws are state laws that establish a maximum legal interest rate that lenders may charge borrowers for loans. These laws are designed to prevent predatory lending practices and protect consumers from excessive interest rates. However, there are certain types of transactions that are exempt from usury laws, including seller purchase money financing, which involves the seller financing the sale of their own property to a buyer. 7. Which is more closely related to trust deeds than to mortgages? A. Redemption rights after sale. B. Non-judicial sale. C. Deficiency judgments. D. Legal title with borrower. B. Non-judicial sale. Trust deeds and mortgages are both types of security instruments that are used to secure a borrower's repayment of a loan by giving the lender a security interest in the borrower's property. However, trust deeds and mortgages differ in how they handle foreclosures. In a mortgage, foreclosure typically involves a judicial process in which the lender must go to court to obtain a foreclosure order. In contrast, a trust deed allows for non-judicial foreclosure, which means the lender can foreclose on the property without going through the court system. Redemption rights after sale, deficiency judgments, and legal title with the borrower are all concepts that apply to both mortgages and trust deeds. Therefore, option B, non-judicial sale, is the answer that is more closely related to trust deeds than mortgages. 9. Which is a true statement regarding trust deeds? A. A trust deed is a two-party instrument. B. Legal title is held by the beneficiary. C. Trustor can reinstate up to 5 business days before sale. D. Foreclosure would wipe out all other encumbrances. Answer C. Trustor can reinstate up to 5 business days before sale. 10. The total required foreclosure time under a trust deed, power of sale, is most nearly A. 4 months. B. 9 months. C. 1 year. D. 18 months. A. 4 months. In a trust deed, foreclosure typically involves a non-judicial sale, also known as a power of sale, which allows the trustee to foreclose on the property without going through the court system. The time required for foreclosure under a trust deed can vary depending on state law and other factors, but the total required foreclosure time is generally shorter than that of a judicial foreclosure. In some states, the foreclosure process under a trust deed can be completed in as little as 4 months. Therefore, option A, 4 months, is the answer that is most nearly correct. Options B, C, and D are all longer than the typical time required for foreclosure under a trust deed. 11. The beneficiary of a second trust deed would be most likely to insist on a subordination clause. B. Request for notification of default. C. Subrogation clause. D. Financing statement. Answer. B. Request for notification of default. 13. A financing instrument whereby the seller retains the legal title is a trust deed. B. Mortgage. C. Real property sales contract. D. Subordination agreement. C. Real property sales contract. A real property sales contract is a financing instrument in which the seller retains legal title to the property until the buyer has fulfilled all of their obligations under the contract, such as making all required payments. The buyer typically takes possession of the property and has an equitable interest in it, but legal title remains with the seller until the contract is fully performed. A trust deed and a mortgage are both types of security instruments used to secure a loan with real property. In a trust deed, legal title is held by a neutral third-party trustee, while in a mortgage, legal title is held by the borrower. A subordination agreement is a contract between two lien holders that establishes the priority of their liens. Therefore, the correct answer is C. Real property sales contract. 14. Which element need not be included in a real property sales contract? A. The number of years required to pay it off. B. A legal description. C. A subordination agreement. D. The basis for tax payments when taxes are included. C. A subordination agreement. A real property sales contract is a financing instrument used in a purchase transaction where the seller retains legal title to the property until the buyer has fulfilled all of their obligations under the contract. The contract should include certain essential elements, such as a legal description of the property, the purchase price, and the terms of payment. Option A, the number of years required to pay off the contract, is an important element that should be included to establish the length of the payment period. Option B, a legal description, is necessary to accurately describe the property being sold. Option D, the basis for tax payments when taxes are included, is important to ensure that the parties understand their respective responsibilities for paying property taxes. Option C, a subordination agreement, is not an essential element of a real property sales contract. A subordination agreement is a separate contract between two lien holders that establishes the priority of their liens. While it may be included as part of the financing arrangement, it is not necessary for the basic elements of a sales contract. Therefore, the correct answer is C, a subordination agreement. 15. A dragnet clause in a trust deed covers A. Any contingency. B. Future advances. C. Additional parties. D. Increases in the interest rate. B. Future advances. A dragnet clause is a provision in a trust deed that secures not only the existing debt but also any future advances made by the lender to the borrower. This means that the lender can add to the amount secured by the trust deed without having to execute a new trust deed or mortgage. Option A, any contingency, is too broad and not accurate as a dragnet clause is specific to future advances. Option C, additional parties, is not accurate as a dragnet clause is related to the debt and not to parties. Option D, increases in the interest rate, is also not accurate as a dragnet clause is related to future advances, not changes in the interest rate. Therefore, the correct answer is B, future advances. 18. A subordination clause in a trust deed is of greatest benefit to the A. Truster. B. Beneficiary. C. Trustee. D. Tenant. A. Truster. A subordination clause is a provision in a trust deed that allows a junior lien to take priority over the trust deed in certain circumstances. This is typically used when a borrower wants to obtain additional financing secured by the property. By agreeing to a subordination clause, The beneficiary of the trust deed agrees to allow the new lender to take a higher priority lien position on the property. The greatest benefit of a subordination clause is to the trustor, or borrower. By obtaining additional financing, the borrower may be able to use the funds for other investments or to pay off higher interest debts, which can be financially beneficial. Additionally, the borrower may be able to qualify for a lower interest rate on the new loan. Option B, beneficiary, would be disadvantaged by the subordination clause as it would subordinate their lien position to the new lender. Option C, trustee, is not directly impacted by the subordination clause. Option D, tenant, is not relevant as the subordination clause pertains to lien priority and not tenancy. Therefore, the correct answer is A, trustor. 19. The Service Members Civil Relief Act of 2003 protects citizen soldiers by A, limiting credit obligations entered into before active duty to 5%. B, allowing courts to stay foreclosure for up to 2 years after active service ends. C, allowing service personnel to terminate residential leases if transferred. D, prohibiting any eviction of a service member's family while the service member is on active duty. Answer: allowing service personnel to terminate residential leases if transferred. The Service Members Civil Relief Act, SCRA, of 2003 provides a range of protections for active duty service members, including protection against eviction. Specifically, the SCRA prohibits landlords from evicting a service member's family from a residence during a period of military service without a court order, even if the lease has expired or been terminated. 20. A financing statement is removed from the records by A, final payment of the debt. B, a reconveyance deed. C, a notice of abandonment. D, the filing of a termination statement. D, the filing of a termination statement. A financing statement is a public record that is filed with the appropriate state agency to give notice of a security interest in personal property. When the debt is fully paid off or the secured party no longer has a security interest in the property, the financing statement must be terminated. This is done by filing a termination statement with the same agency that received the original financing statement. Option A is not accurate because final payment of the debt does not automatically remove the financing statement from the records. Option B is not accurate because a reconveyance deed is used to transfer legal title of real property from a trustee to a trustor, borrower once a debt is fully paid off. Option C is not accurate because a notice of abandonment is not used to remove a financing statement from the records, but rather to give notice that a secured party has abandoned their security interest in the property. Therefore, the correct answer is D, the filing of a termination statement. Unit 11: Involuntary liens and homesteads. 1. Involuntary liens include all except A, judgment liens. B, tax liens. C, attachment. D, trust deeds. D, trust deeds. Explanation: involuntary liens are placed on a property without the owner's consent or agreement. They are usually imposed by law or court order to secure the payment of a debt or obligation. Judgment liens, tax liens, and attachments are all examples of involuntary liens. Trust deeds, on the other hand, are voluntary liens, meaning they are created with the property owner's consent and are used as security for a loan. 3. Henry was injured while swimming in the pool of his neighbor Tom. Henry obtained a $100,000 judgment against Tom. As applied to Tom's house, this would be A, an unenforceable lien. B, a general lien. C, a specific lien. D, a priority lien. Answer: B, a general lien. Explanation: a general lien is a lien that attaches to all of the property of a debtor, rather than a specific property or asset. In this case, Henry's judgment against Tom would likely be considered a general lien since it would attach to all of Tom's property, including his house. 4. To create a lien after judgment, the creditor would file A, a writ of attachment. B, an execution of judgment. C, an abstract of judgment. D, none of these. The correct answer is C, an abstract of judgment. After a judgment is entered in favor of the creditor may file an abstract of judgment with the county recorder's office in any county where the debtor owns real property. The abstract of judgment creates a lien on the debtor's real property in that county. The lien gives the creditor a security interest in the property and ensures that the creditor will be paid if the property is sold or refinanced. 8. An attachment is a lien for A, 3 years from the date of levy. B, 4 years from the date of levy. C, 10 years from the date of levy. D. 10 years from recordation. Answer A. 3 years from the date of levy. The correct answer is A. 3 years from the date of levy. 13. An unlicensed person who has mechanics lien rights would be A. A general contractor. B. A subcontractor. C. An independent contractor. D. An employee of the contractor. Answer D. An employee of the contractor. 14. A notice of non-responsibility would not be filed by A. Vendor under a real property sales contract. B. Lessor. C. Beneficiary of a prior recorded trust deed. D. Any of these. C. Beneficiary of a prior recorded trust deed. A notice of non-responsibility would not be filed by a beneficiary of a prior recorded trust deed. A notice of non-responsibility is a legal document that is filed by a property owner to indicate that they are not responsible for the payment of any debts, obligations, or liens that may have been incurred by someone else in relation to their property. This is typically done in situations where work has been performed or materials have been supplied to the property by a contractor or supplier, but the property owner has not authorized or contracted for the work or materials themselves. By filing a notice of non-responsibility, the property owner can protect themselves from being held liable for any debts or liens that may arise as a result of the work or materials supplied by the contractor or supplier. 15. A preliminary notice was filed by a contractor 40 days after work started. The period covered by a subsequent lien would start A. With the notice. B. 20 days before notice. C. 20 days after notice. D. At none of these times. Answer B. 20 days before notice. Preliminary notice to prevent secret liens or lien claimants. A preliminary notice must be given before the recording of a mechanic's lien. To fully protect lien rights, the mechanic should file a preliminary notice that the work is subject to lien rights within 20 days of starting work. If the notice is given later, any subsequent liens will cover only the work starting 20 days before filing. 16. If there is no notice of completion, subcontractors have how many days to file their liens after completion? A. 30B. 60C. 90D. 180. C. 90. In California, if there is no notice of completion, subcontractors have 90 days to file their liens after completion. 17. A contractor started a foundation for a new dwelling, but the owner was not satisfied with his work and paid him off. 3 weeks later, the owner got a construction loan secured by a trust deed, which was recorded. The owner proceeded to hire another contractor to build his home, and when the building was finally completed, a painting subcontractor filed a mechanic's lien against the property. What is the result in this case? A. The trust deed takes priority over the mechanic's lien. B. The mechanic's lien will take priority because a mechanic's lien always takes priority over a trust deed. C. The subcontractor will not be able to file against the property but will be able to file a lien against the contractor's property. D. The mechanic's lien will take priority over the trust deed because some work was done before the trust deed was recorded. D. The mechanic's lien will take priority over the trust deed because some work was done before the trust deed was recorded. The mechanic's lien takes priority over the trust deed to the extent of work done and materials furnished prior to the time of the execution of the trust deed. Since the painting subcontractor filed a lien after the owner obtained a construction loan secured by a trust deed, the trust deed would take priority over any lien for work performed after the trust deed was recorded, but the painting subcontractor would have a priority lien for any work performed before the trust deed was recorded. 18. A stop notice A. Requires that a contractor stop work. B. Is a lien on construction funds held by a lender. C. Is equivalent to a lis pendens notice. D. Is none of these. B. A stop notice is a notice to a construction lender to stop disbursing funds to the contractor or subcontractor until the stop notice claimant's dispute with the contractor or subcontractor is resolved. It is a lien on construction funds held by a lender. 21. A purchaser of a condominium unit filed a declaration of homestead. The purchaser refused to pay his assessment fees, and the owners association filed a lien. The lien would be A. Void because homesteaded property is protected against liens. B. Enforceable only if the owner's equity exceeds his homestead exemption. C. Collectible as if there were no homestead. D. Valid but collectible only when the homestead is sold. The correct answer is C. The lien filed by the owners association would be collectible as if there were no homestead. Filing a declaration of homestead does not protect the owner against liens for unpaid assessment fees, as these fees are considered a common expense and are necessary for the maintenance and operation of the condominium project. The homestead exemption protects the owner's equity in the property from certain types of creditors, but not from liens for common expenses. Unit 12 Adjacent property rights. 3. An action for the removal of a permanent encroachment must be commenced within a 3 years of the encroachment. B. 4 years of the encroachment. C. 10 years of the encroachment. D. A reasonable period. Answer A. 3 years of the encroachment. 6. A dispute between riparian rights holders would likely be heard by the A. Federal District Court. B. Local water agency. C. Water Resources Control Board. D. None of these. Answer C. Water Resources Control Board. 9. Little rights refer to A. The underground water table. B. Water within a defined flowing channel. C. Non-flowing water. D. The right of ingress and egress. Answer C. Non-flowing water. That is correct. Littoral rights are the rights of a property owner whose land borders a lake, sea, or ocean. These rights usually extend to the high water mark and include the right to use the water for certain purposes, such as swimming or boating, but not the right to extract water from the body of water itself. Littoral rights apply to non-flowing water, as opposed to riparian rights, which apply to flowing water. 13. An owner who excavates on her property below the level of a neighbor's foundation is A. Always responsible for damages to her neighbor's structure. B. Required to give notice to the neighbor of the proposed excavation. C. Both of these. D. Neither of these. B. Required to give notice to the neighbor of the proposed excavation. 17. Owners may not protect themselves against users obtaining prescriptive easements by A. Recording a permissible use statement. B. Posting right to pass by permission and subject to control of owner. C. Ordering wrongful users to cease their trespass. D. Doing any of these. Owners may not C. Ordering wrongful users to cease their trespass. 18. A grant of mineral rights made no mention of an easement to enter the property. What are the rights of the mineral rights holder? C. The holder has an implied easement to enter and mine. Yes, that is correct. In general, a grant of mineral rights implies an easement for the purpose of exploring, drilling, and extracting minerals from the property. This easement is limited to what is reasonably necessary for the exercise of the mineral rights and does not give the mineral rights holder the right to use the surface of the property for other purposes without the owner's consent. 20. An easement by necessity requires A. Payment for the easement right. B. Former common ownership of the dominant and servient tenements. C. Both of these. D. Neither of these. The correct answer is B. Former common ownership of the dominant and servient tenements. An easement by necessity arises when it is absolutely necessary for a landowner to have an easement in order to access their landlocked property, and there is no other reasonable way to access the property. This type of easement is created by law and does not require payment for the easement right. However, it does require that the dominant and servient tenements were previously owned by the same person. 22. An easement by grant will be lost through A. Nonus. B. Foreclosure of a prior lien. C. Merger of the dominant and servient estates. D. Both B and C. D. Both B and C. An easement by grant can be lost through foreclosure of a prior lien or through the merger of the dominant and servient estates. Nonus does not generally affect an easement by grant. 23. Which would not terminate an easement created by grant. A. The destruction of the servient tenement. B. A merger. C. Nonus. D. A quitclaim deed to the encumbered property from the dominant tenement to the servient tenement. Would not terminate. C. Nonus. 24. For 6 years, Alfred, with Smith's permission, used a shortcut over Smith's land to get to his home. Alfred likely now has A. An easement by necessity. B. An easement in gross. C. An easement by prescription. D. A license. Answer D. A license. Since Alfred had Smith's permission to use the shortcut, he does not have any type of easement, by necessity, in gross, or by prescription. Instead, He has a license, which is a revocable permission to use another person's land for a specific purpose. As Smith granted the permission, he could revoke it at any time. 25. What is not true regarding a license? A. It goes with the land. B. It is an interest in real estate. C. It can be inherited. D. None of these are true. D. None of these are true. A license is not an interest in real estate and does not go with the land. It is merely a revocable privilege or permission to do something on someone else's property, and it is not inheritable.